wouldn't be aware of. So this is why an attorney is extremely important.
And even if it's a small matter, if there's a condition of a good, a guarantee, it's also good to have all those details to reflect your understanding written down as part of the contract. Because once you sign it, you may have it be assumed to agree to it, and it's going to be hard to negotiate. It's going to be hard to enforce any verbal details.
Yeah, absolutely. In fact, there's something very quickly that I'll get into called the parole evidence rule. And to just give that a very quick layman's explanation, it basically means you can't use any interpretation outside of a written agreement to interpret that agreement afterwards. So that if you have terms in an agreement which are X and you want to say after the agreement is signed, oh, I really meant Y, you're going to be stuck.
Okay, I wish we had more time on that, but in a few minutes we'll talk about the breaking of a contract. And my guest is Elan Weinreb, and he's an expert in contracts and commercial litigation and also alternate dispute resolution. You're listening to Law You Should Know here on 90.3 WHPC, the voice of Nassau Community College, and also over the internet at nccradio.org. We'll be back in a moment.
This portion of programming on WHPC is brought to you on behalf of the Nassau County Bar Association, helping both the public and lawyers since 1899. They are the largest suburban bar association in the country. The Nassau County Bar Association offers clinics where you can meet privately with an attorney to prevent or solve legal problems involving Hurricane Sandy, foreclosure, wills, or elder law. Speakers on almost any legal topic are also available to schools or community groups. They can also help lawyers advance their legal careers and offer a place to network. Learn more about the Nassau County Bar Association by calling 516-747-4070 or visit nassaubar.org.
Once again, we continue with Law You Should Know. From the Mineola Law Firm of Shane, Dox, Denisi, Corker, and Sauer, here is attorney Kenneth J. Landau.
Hi, this is Ken Landau, and welcome back to Law You Should Know. Today we're talking about making and breaking contracts, and our guest is Elan Weinreb, and he has his own firm in Garden City. He's a very experienced commercial litigator. He's also experienced in drafting and suing over contracts. I just want to remind our listeners, whatever you're hearing today is presented as information only. To review a contract or for legal advice, you must have an attorney advise you about your particular situation. Elan, let's talk about breaking a contract in general.
Okay, so we talked about making a contract before. Just to quickly review, you got to offer acceptance and consideration. And once you have that manifestation of assent for all those three terms, then the question becomes, how do you conduct yourself in the contract? Sometimes you want to get out of it. And there are ways of doing that, even though it's not advisable, and the law presumes that once people have a contract, they're going to do their best to perform. There are certain what is called defenses or justifications for getting out of a contract, some of which, though, are encapsulated or incorporated within certain provisions. Now, again, the objective of a contract is to make sure it's performed. So these provisions, what's called boilerplate, and that's after the standard printing press plates that were used some time ago in newspapers. That's where the term comes from. These boilerplate standard provisions are designed to let people have a certainty of performance in the contract and also to allow them to get out.
But I just want to say, and a boilerplate may be a typical pre-printed contract, but whichever side you're on, if you want to modify it, the time to do it is before you sign the contract.
Absolutely.
Once you sign, you may, except for the reasons I'm going to mention, you may be bound to it. So if you have other terms that you want included, you have to really write them onto that boilerplate form.
That's correct.
Or cross out terms that are not going to apply to you.
Right. So in terms of what you have in boilerplate and in terms of getting out of a contract, sometimes you have, and in some ways boilerplate sometimes does the reverse. You have sometimes what's called a force majeure clause. People call this an act of God clause.
Let's say there's a hurricane or something.
Exactly. So a natural disaster. We had Hurricane Sandy a couple of years ago. And in those cases, you have a specific provision that allows you to either get out of the contract or alternatively requires people to stay in, depending upon how the clause is drafted. More often than not, usually force majeure clauses allow the parties to get out because a basic assumption of the initial contract, which is that the items or whatever that are part of the contract would exist, has been broken. And once we have that frustration of assumption of the initial party's intent, then that manifestation of assent goes by the wayside, and that's one way of getting out. You could have a force majeure.
And what if there's a mutual mistake?
Yes, mutual mistake does work, provided that, again, it's a real mistake, and you have both parties having a completely different understanding of what's gone on. On the other hand, sometimes you have a mutual mistake and what appears to be a different understanding, but one party has a different level of that mistake. So in that aspect, it's not truly mutual. It's not easy when you have a mutual mistake to get out, especially in a written contract, because of the nature of the writings. Very often, if you have a good attorney, and this is very important again, why to have an attorney who's drafting a clear writing, then you have it. There is a famous case that I'll just mention quickly called the Peerless case, where one party had an understanding that the ship called the Peerless was going to be delivering cotton on 1 month, and another, I think it was December, and another party had the understanding that it was going to be earlier in the year. It was going to be a May shipment of the Peerless, and because they both had a demonstrative different understanding of which ship was going out, even though both of them were Peerless, was different times of the year, the court said, okay, there's mutual mistake, no contract, this didn't happen.
And even if you're using an attorney, you want to make sure you understand all the terms as they are written, because you're the one who's going to have to perform them, and you want to double check the times, the dates, and the numbers involved.
Absolutely. If you are drafting a contract, and it's not so much that I do drafting of contracts, I sort of, in my practice, analyze contracts from the opposite end when people sort of run into trouble, and people have disagreements and people have misunderstandings or disputes. That's what I do, is dispute resolution. But if you are drafting, and you could always advise people, and I've done this before also, when you advise people how to avoid these problems in the first place, if you're drafting, you have to make sure that everything is crystal clear. And in fact, sometimes what you want to do is play devil's advocate. You want to see what the worst case scenarios could be, and based upon what you think is coming up or any sort of ambiguities, you want to draft around that. It's not always possible to get everything, but you want to do
and
the best
just for a minute, let's just talk about ADR provisions.
Right. So then ADR is actually another way that parties can in some ways get out of a contract. That's ADR is defined as alternative dispute resolution and includes a wide variety of dispute resolution mechanisms that allow people to avoid court or traditional litigation.
If there's a problem with the contract.
Correct, exactly. So if people, let's say, have a disagreement and there's a mediation clause, if the contract provides for, again, going to mediation, a skilled mediator may convince the parties that it's not practical for them to continue with the contract, or may decide to modify, or to mediators really aren't supposed to advocate, but get to the parties to agree to facilitate a modification of the contract, and that aspect getting out of it. Alternatively, a mediator sometimes can facilitate breaking a contract.
So this way you may be bound to go to court. This may keep one or both parties from going to court if there's some kind of arbitration or ADR provision. That's
correct. And it's also sometimes an incentive insofar as that if a tiered process, meaning mediation, then followed by arbitration, then followed by litigation, and this is the clause for the Nassau County Bar Association, their ADR committee does have a clause which is tiered in that the parties are first to go to mediation, then arbitration, litigation. There are a lot of reasons for that I'm not going to get into, but that tiered system very often can provide a way for getting out of a contract because parties don't necessarily want to have to go through all of them.
Now, if both parties agree to cancel or revise a contract, there should be another writing confirming that?
Absolutely. There's no question that you need another writing to do that, because you need and not just another writing, you need additional consideration to support that.
Again, we don't have too much time left in the show, but if you feel there's a notice provision, you want to make sure that's strictly complied with. If there's a performance problem, you should let someone know, preferably in writing, and follow whatever notice provisions there are on the contract.
Yes, absolutely. And sometimes you actually have law which requires you to draft a notice provision in a specific manner. I mean, just very quickly, you have New York General Obligations Law, Section 59032, which deals with repair, maintenance, and service contracts. If you have somebody, we're going to the summer now, mowing your lawn, and these provisions are called evergreen clauses, that's why I'm using a landscaping example. If you have someone mowing your lawn and they say, okay, well, I'm going to mow your lawn from May through October of 1 year, and guess what? This contract automatically renews beforehand. If they don't give you that notice that you have a renewal coming up from April 15th to April 30th, is at least 15 days before, or maximum 30 days before, from April 1st to April 30th under the General Obligations Law, you actually have a way of getting out.
Okay, and we just have very little time, but if you don't want a renewal clause, you can try to take it out of a boilerplate contract, and if both parties to agree to it, that will be part of it.
Absolutely. The parties can modify things as they see fit, but generally speaking, when you have renewal clauses, you should try to look at other contracts to get an idea of what people view as a good renewal period. More often than not, the industry standard is 30 days.
Okay. If there's misrepresentation by one party or another, is that a grounds for breaking a contract?
Yeah, absolutely. You have sometimes a misrepresentation that rises to the level of a fraud. That's a specific type of misrepresentation that you could use to break a contract called fraudulent inducement. Sometimes you have just a regular misrepresentation that's made that people didn't know what the terms or the status of a specific item was, and they fudged it. If that's the case and they should have known, you can sometimes get out of a contract for that reason as well.
And again, even if someone did not consult, on either side did not consult an attorney before the contract was entered, if there's a contract and it's not working out for one or both of them, they still have an opportunity to consult an attorney about what their options might be.
Yeah, absolutely. You always have an option to consult an attorney, but keep in mind this, and I've seen this come up a lot, people have a notion that if they don't understand a term, that gives them a defense. That's not the case.
Okay. We just have 15 seconds left. Any final thoughts you'd like to give? And just give us your website again.
Yeah, sure. So my website is www.weinreblaw.com. And I would say that for anybody entering into contracts, which again we do every day, we all go to the store and we certainly go to eat in restaurants, and we have other transactions which we conduct on a regular basis. But anytime you're getting into a very serious transaction and you really have a lot of money or other value at stake, it's imperative to consult an attorney.
And even if it's a bill of sale, you're purchasing goods, you want to put in writing on that item when it's going to be delivered, what day of the week, what time frame, whatever you feel you're agreeing to.
Yeah, and if you don't, the courts sometimes will imply that term for you, so you have to be careful.
I wish we had some more time, but I'd like to thank our guest, Elan Weinreb with the office right in Garden City, for being our guest on Law You Should Know. And please join us next week at this same time on 90.3 WHPC, the voice of Nassau Community College, or over the internet, nccradio.org. And keep in mind, podcasts of this show are available by searching WHPC on iTunes.